Jefferson County Court Law number 2 is now in session. The court is in session on today's date, October 13, 2023, with the announcement docket. First case is cause number M329630. Case is styled the State of Texas versus David Kenneth Tand. Mr. Tand, would you please come forward? Do I have bond? Tand. Mr. Tan, your full name is David Kenneth Tan?
Yes, sir.
How you doing, Mr. Tan?
Good, sir.
That's good. Mr. Tan, you're represented in your case by your attorney, Marcus Wilkerson. Attorney Wilkerson, how are you doing?
I'm doing well, Judge. Thank you.
And the state is represented in this case by Attorney Colby Hallpower. Attorney Hallpower, how are you doing?
Good.
Mr. Wilkerson, what is your announcement in Mr. Tan's case?
Your Honor, after conferring with the state's attorney, we'd like to request a reset to a Tuesday docket.
Tuesday?
Yes,
Okay.
sir.
Okay, give us a reset date.
Judge, what we'd like to do on that, just of course, due to the nature of this particular alleged act and there's a history with this defendant, I think he's been working with our mental health officer that comes on Tuesday. I would like to, if the court's okay with that,
Okay.
reset this because he can provide me the information I need from Spindletop and from this is the sheriff's department. Kate, it sounds like he may have, unless we got more than one, and I don't think we do. I think we only have one mental health officer with our sheriff's department. Unless the court knows we don't. We have more than one.
Well,
At least he's one who could give me the information I need, what we can do with this particular case, because my understanding is there is a history with the sheriff's office, mental health officer, and with Spindletop.
oh, okay.
So that's why I'd like to do it on a Tuesday, because usually he's here for our arraignment
Yeah.
docket.
It's
Is that
about
a-
30 day reset. November, okay.
This is long, it'd be a good day to do it on that Tuesday.
Okay. So we're gonna reset this case to November 14th at 9 a.m. Mr. Tan, your attorney is gonna get your reset. Once you get your reset from your attorney, you'll be free to go, and you have a blessed day. All right. And Mr. Wilkerson, I think this is on the case, so you're free to go as well, and you have a blessed day.
Thank you, Your Honor.
You're welcome.
Judge, Mr. Deal or Ms. Scott.
Okay. We don't have it, please. Okay, this is,
Or we can put it remote like if you want to report on Friday. If he's got the credit on it, no,
mm,
we'll send him over there. Look at it.
well, he leaves from here.
We just give him credit.
If he got the time, yeah.
Yeah, okay. I mean, unless you got to look, you got a deal for him.
Hold on a minute. Let's see. Is this on Matthew Wiley?
Yes, Your Honor.
Oh, that's the gentleman that, hold on. Just wait for them to,
Yeah,
she should bring him back out.
Well, I talked to him, he just got
Okay, this is cause number M 320-936, case of solid state of Texas versus Matthew Joseph Wiley. Mr. Wiley, is that your full name? No, Mr. Wiley, how are you doing? You all right? Now, Mr. Wiley, you're represented in your case by your attorney, John Macy. Attorney Macy, how are you doing? Now, Mr. Macy, I understand that Mr. Wiley has 2 new active warrants in 2 cases. Is that correct?
That's my understanding of it, Your Honor. So I'd ask that the case be reset so that we can find out whether or not, well, irrespective of what, I need to know what they are if we try to deal with this case.
Okay.
Judge, they have been filed, they do have cause numbers, it's just, they're not on our stuff yet. It's not like it's in intake that's waiting to be filed, but we have cause numbers, so.
Yeah, I see them. It's on the cause numbers on the docket
Yes.
sheet. Now, let's see, Mr. Wiley, obviously you've been taken into custody. Your attorney is going to get your resets on your cases. Your attorney is going to stay in contact with you. He needs time to look at these 2 new cases, do the discovery, and then to have a conference with the DA's office and you. Okay. So, Mr. Wiley, at this time, you can follow the bailiff. Okay. And the magistrate will be setting a bond in each one of these new cases. Okay. Thanks, Tim.
I'm here now. I'm carrying on the meeting except for, depending on what it is, because Thursday.
Jefferson County Court Law number 2 is back in session and cause numbers 23 CCCR 0716, cause number 23 CCCR 0717, and cause number 23 CCCR 0718. All three cases are filed in the state of Texas versus Servion Xavier Abdullah. Mr. Abdullah, is that your full name? Okay, how you doing, Mr. Abdullah? I'm doing fine, thanks for asking. Now, Mr. Abdullah, you were here on August 15th of 2023. At that time, you signed the judge's explanation of rights to defendants without attorney. And on that document, you indicated that you wanted your case to be reset to hire your own attorney. Have you hired your attorney? Why haven't you hired an attorney? You don't have the funds, okay. Now, you also, in that document, it also informed you that if you did not have enough money to hire an attorney, you may request an attorney to be appointed to represent you. You would have to fill out what is called an affidavit. Do you understand that? Now, would you like to fill out an affidavit to see if you qualify for a court-appointed attorney? Okay, just have a seat, and we're going to have someone to get the paperwork to you. All right.
Judge, Ms. Peraza, when we were doing jail run yesterday, she said that she had something.
I think that wasn't that reset. When it's supposed to be reset.
I think it might have been reset she was talking about. That was one.
Olivia Dakota,
Is that we filed an amendment of the
arrest search.
information, yeah,
Oh, y'all did?
to get, and it was on the trial docket. I don't know if you remember a couple of weeks ago. It had the wrong guy.
Oh, yeah, I did
So,
remember something about
I
that.
refiled it with the right officer. But
Oh,
I know
okay,
she got it reset or whatever, but it's fine. And whenever we do it, I just want to remind the court that that was a trial docket one. We had it worked out. I just had
You
to.
probably need to put it back on the trial. Ms.
Now,
Jackson,
she's got time served
okay,
with the new guy. So it needs to be a pretrial or a arraignment, not the trial docket, because they've agreed to an offer
okay,
and there's no reason to
okay. That's Olivia Nicole Dakota.
go.
Has that been reset yet? Okay, we're good. Now, is Mr. Dakota here?
You didn't answer.
I
But
think that
she was supposed to get it reset yesterday,
She
Ms.
was-
Peraza.
Peraza went.
Did she talk to one of the other coordinators? Next case is cause number M332706. Case is filed in the state of Texas versus Elliot Travon Butler. Mr. Butler, you can take your mic off of mute. Mr. Butler, how are you doing?
I'm doing all right.
Now, Mr. Butler, last time that you were here, your attorney at the time, which was Tyler Blanc, was granted his motion to withdraw. You had signed a judge's explanation of rights of defendants without attorney. And on that document, you indicated that you wanted to waive your right to an attorney to represent yourself. You also signed a waiver of counsel in that case. Now, my question to you is, have you had an opportunity to set up an appointment with the district attorney's office to review the file?
I've tried, just transportation is very hard right now.
Okay. Now, if I'm not mistaken, you live in Louisiana?
Yeah, at the moment I had moved back home.
Okay.
I was staying in Texas.
All right. So what we're going to do is we're going to give you an opportunity to, now you're going to have to contact the district attorney's office to set up an appointment so that you can review the state's file, okay?
All right, and could I ask you something?
Okay.
Being that I haven't reviewed the file, could the file be played in court?
I don't think so. He was saying played in court. Now, there's some you have to set up an appointment. It's like having a private a conference with the district attorney's office, and so that's not public.
Yeah, so none of the evidence that I'm going to view.
It's not public. You have to view that in the district attorney's office.
So what I'm asking is, will that evidence, the evidence that I'm viewing, will that be used in court?
Oh, yeah, I'm sure it'll be used in trial if that's what you're asking.
Right, so I won't be able to view it in trial?
Okay, so I mean, only thing I'm saying is if you put it like this, if you, they're gonna give you an opportunity to review your case in advance of trial. Okay, so that you can prepare for trial. You won't be.
Yeah, but I know I haven't done anything, so I'm not worried about it.
Okay,
Like I said, I have reputation issues, and it's hard for me to make it to see that. So I'm asking that for a reason, because I don't mind it being played in court, and from there I can go along with what needs to be going on or needs to be said, because I can tell you honestly what happened.
Okay, so
I have nothing to hide. I'm just trying to get this done with.
Mr. Butler, based on what you're saying, I think what you're saying is you want me to set this case for trial. Is that correct?
I've been saying this, Judge, ever since I've been coming up there. Yes, sir. That's why I don't want a lawyer. I've been asking for lawyers. No one trying to help me, and I have nothing to hide. I'm trying to get the case done with and get it put forward.
Okay, Mr. Elliott.
I have a child. She's 2.
Mr. Elliott.
Now, and I've been dealing with this case since she was 4 months.
Okay, Mr. Elliott. What we're going to do, state.
I understand what the council's arguing for. I mean, the defendant is arguing for, but he's got to come to court before we do anything. The state's going to ask him to.
I have been coming.
For him to come, not over Zoom, unless he's sick or he's got COVID or he's in Alaska. We can't do anything unless he can't be for the reason right now. Like,
just hold on. Now, Mr. Elliott, what the state is saying is that they want you to make it a personal appearance in court and to make your announcement for trial on that date. Okay?
What about the times I have done that? They're not going to tell me, say nothing about that?
What I want to do, Judge, is also
2 years.
Hold on, Mr. Elliott. Mr. Butler, the prosecutor is talking. You can't, 2 people can't talk at the same time. Just let the prosecutor say what he has to say first. Okay, then we'll give you an opportunity to talk, and the prosecutor won't be talking while you're talking. Okay? Now, Mr. Hopper, what were you saying?
What, the reason why I'm saying that, Judge, is that we could do it at that time. It won't be on for trial at that time, but an announcement. That way I can set an appointment for him to look at the evidence. If he's a pro se defendant, so we can have an appointment to come look at his evidence. Therefore, he wouldn't be for trial, and they would try to rush that.
But,
That's my only thing.
okay,
That's why I'm saying that.
but I think what he's saying, and you could correct me if I'm wrong, Mr. Butler. Mr. Butler is saying that he don't want to look at the evidence before trial.
Right, right. Right.
Caution.
And if we go- Can I say something?
Wait. Mr. Hoffpower was talking. We'll let you say something, Mr. Butler.
Out of
Okay.
abundance of caution, and it's not against what the defendant wants to do, but for the state, if we do it wrong, it comes back. Therefore, and it's a pro se, the court knows there are a lot more things we need to make sure go right if it's a pro se defendant. Therefore, I'd just like to make sure we give an opportunity. It's on the record that we gave him an opportunity to go look at the evidence. All those things, we're just trying to make sure it's done properly with a pro se defendant. That's the only reason why I wanted to do an announcement first and then a jury.
Now, Mr. Butler, did you hear that?
Not clearly.
Okay. Hold on a minute. Okay, could you repeat?
The only thing, because it's a pro se, and as the court knows, that's a unique thing. It's okay, somebody can represent themselves, but the state's responsibility is to make sure it's a fair trial as well. And we also have to follow the steps to make sure he's got access to the discovery. Therefore, we need to put it on the record. We gave him an opportunity. He was in court, not on Zoom. He was in the court and he was instructed. He's got an opportunity. If he doesn't want to do that, that's fine. But the state has to follow these steps in order for it to be a fair trial. We believe it covers the state. Should the resolution come about and somehow they go back, so we didn't give them an opportunity to look at the discovery. That way we're covering our bases. It's out of the abundance of caution. It's not to punish the defendant or to delay the trial.
Now, Mr. Butler, did you hear that?
Yeah, I heard him.
Okay. So,
But I'm not understanding what he's trying to tell me. He's saying that I get what I heard him, but it's not making sense on why I have to if the video being played, if the evidence is being used in court, why I have to use it. Like, why do I have to go watch it if it's being used in court when it can still be played? Like, either way it go, like it's not making sense. It's really not making sense to me.
okay, no, what he's saying is because you, okay, Mr. Butler, what he's saying is because you are representing yourself and you do not have an attorney to represent you, of the abundance of caution, they want to make sure that everything is done the way it's supposed to be done. In essence, you are not being railroaded or no one is trying to trample on the rights that you have. And so they want to make sure that they do everything that they're required to do by law. That's what he's saying.
All right. So,
Okay.
So what
what we're gonna do, we're gonna give you we're gonna reset the case, give you an opportunity to come in person, and at that time, then you'll be able to either set up an appointment with the prosecutor to review the discovery, or you can have they may have a document saying that you were given an opportunity to review the discovery and you have decided to waive your right to review that discovery. All of this here is going to be documented. Okay. And so what we're going to do, we're going to reset this
all right,
case.
so can I just waive the discovery?
Yeah, but you got to be here in person. We can't do it over the
all right.
So
Why wouldn't I told this before? Like, why couldn't I be told this beforehand?
Because you said because at that time you was going to set up an appointment to do this, to view the discovery. And you said that you have made attempts, but you have not, I guess, you have not been able to talk to anyone in the DA's office to set up that appointment. And so what we're going to do is make sure that the next court setting that you'll be here, you'll have the opportunity. If you want to review it, you'll be allowed to review it. If you do not want to review it, then you'll sign a document stating that you had the opportunity to review discovery, and it was your decision that you made voluntarily and knowingly not to review or have access to the discovery. You, in essence, you'll be waiving your right. Okay, so what we're gonna do is just reset this case and give us a reset.
I'm going, so can I say something, Judge?
Okay, go ahead on.
I'm sorry, not to keep on talking. At the end of the day, so I'm gonna keep being held for something I know I didn't done, and I do not mind the video be playing in court. So I'm gonna keep being held with, I gotta keep being held. My rights, I gotta keep being held with these folks knowing that I did nothing. And if they have a proof of me doing anything, I'll be in jail right now. They can take me right now if they're supposed to have evidence. So while I'm out, I'm tired of this having to go back and forth, man.
Okay.
And my rights actually is being played with because it's not being respected.
Mr. Butler, two things. You don't call me man.
His body.
That's one thing. And the other thing is you need to be here. The court has allowed you to appear by Zoom. However, you will not be allowed to appear by Zoom anymore. Okay, you need to be here in person.
All right. And if I can't, I'll just call y'all and let y'all know if I can't make it. That's all I can do. Because I've been coming and I've been showing up. And I'm sick of it now. So now y'all telling me this.
No, Mr. Butler, your history is that you've had an attorney. Okay.
I didn't have an attorney, Judge.
Why would the attorney withdraw if he was not your attorney?
That's the point. He didn't withdraw. I didn't even want him. I told you that before he been withdraw. I've been saying I didn't want him because he was not answering the calls. Been trying to get in touch with his judge. I mentioned that. I mentioned that when I came up there.
And he's no longer.
So if he withdraw, that's on him. I didn't want him before he withdraw.
Okay, well, Mr. Butler, you're gonna have to appear here in person. We're gonna give you a reset date. If you do not appear in person, absent any other reasons, but you need to be here in person. Okay, give us a reset date.
I try to make it that person. It just all right, because look, I'm definitely trying to make it that person because I'm sick of my time is being pulled upon this, and nobody want to understand that, and I'm not trying to upset nobody, not trying to upset you, Judge, but my time is being pulled across and be hold for something I know I didn't done. I didn't do it.
Now, Mr. Butler, what we're gonna do? We're gonna try to give you enough time to get your affairs in more order to try to get transportation. So we're going to reset this case. We're going to give you 60 days. We're going to reset it to December 13th. Okay.
December 13th. All right. That's cool.
All right. So this case is reset to December 13th, 2023. Stay in contact with your bondsman. Mr. Butler, you're free to go and you have a blessed day.
You too, man.
Thank you. Not man, it's Judge.
I'm sorry.
Okay.
I'm sorry, Judge. No
all right. All right. We'll talk to you later.
All right.
Okay. Who else we have? Oh, Miss Scott.
Yeah.
Is hers ready?
Yes.
Oh. It went a little longer than I wanted it to go. Man. Well, good morning. Let me get this thing. Man, this thing. It's harder to crank these things back up. Man. Yeah, oh, that's why it's like that. Okay.
I didn't even know
that makes sense now. Yeah. That's why it's like that. Oh man, some notification. Notification. Jefferson County Court Law number 2 is back in session. The court is in session and calls numbers M33237, calls number M332352. Case is styled the state of Texas versus Henry A. Deal. Mr. Deal, is that your full name?
Yes, sir.
Mr. Deal, would you please raise your right hand? Mr. Deal, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Deal, you may put your hand down. How are you doing, Mr. Deal?
Great, how you doing?
I'm doing fine. Thanks for asking. Mr. Deal, you're represented in your case by your attorney. Let's see, where's his name? Miss Lindsay Scott, Attorney Lindsay Scott. Attorney Scott, how are you doing? Attorney Scott, do you waive a record in Mr. Deal's case?
Yes, Your Honor.
State is represented in this case by Attorney Kobe Hoffbar. Attorney Hoffbar, how are you doing?
Good, Your Honor.
Mr. Deal, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Henry A. Deal, on or about March 30th of 2022, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Deal, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Deal, how did you plead guilty? Not guilty, no contest.
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Deal, I also have before me a document that is titled Misdemeanor Plea Information, Plea Admonishment. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on the line next to a box that's
Yes.
checked guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, oh, he didn't sign this.
We went over it, Judge.
Okay, thank you. Okay, Mr. Deal, I also have before me a document that is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal.
Right.
Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you
Right.
understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the
Yes, sir.
line that's titled Defendant?
Yes, sir.
Okay, Mr. Deal, before you sign and issue these documents, did your attorney, Ms. Scott, go over these documents with you? And did you read and understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Deal, are you a citizen of the United States?
Yes, sir.
State, I have before me States Exhibit 1. State, would you like to offer States Exhibit 1 in evidence?
Yes, Your Honor.
Any objections?
None.
No objection. States Exhibit number 1 will be admitted into evidence. Ms. Scott, you advising counsel, Mr. Deal, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Deal, your attorney, Ms. Scott, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal
Yes,
representation?
sir.
Mr. Deal, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
In exchange for plea of guilty no contest, state decree to recommend 12 days in the Jefferson County Jail at the court cost. The defendant has credit for 12 days with that time served and to tax and retirement full cost.
Mr. Deal, the state is offering that you serve 12 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail on this case because you've already served 12 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Now, Mr. Deal, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Deal, I'll follow the pre-bargain agreement that you have entered into with the state. Mr. Deal, this will conclude your case. I'm gonna stand on the X next to your attorney, follow the directions of our clerk. Once you're finished following her directions, you'll be free to go and you have a blessed day.
Thank you. Thank you.
You're welcome. And Mrs. Scott, you're free to go as well and you have a blessed day.
Hello.
Okay. This is cause number M329840, case of style of the state of Texas versus Damon Stace Stanford. We have Mr. Stanford on Zoom. Mr. Stanford, how are you doing?
Yeah, how about yourself?
Did he
Say
freeze?
good. How about yourself?
Oh, I'm doing
Can you hear
fine.
me?
Thanks for asking. Mr. Stanford, you're represented in your case by your attorney, Todd LeBlanc. Attorney LeBlanc, how are you doing?
Good, Judge.
Okay, Mr. LeBlanc, what is your announcement in Mr. Stanford's case?
Yes, Your Honor, this is I think that the offer is a payment of restitution and case will be disposed of, but there might be an issue with the amount, and at any rate, he doesn't have the amount right now. So could we get a reset so I can possibly work that out?
State, yeah,
That's fine, Judge. The stay requested the defendant be here because it can't
Okay.
be done without him here.
okay, now, next, court setting, you and your, client need to be here in person. Give us, now, how much time does he need to get the restitution?
Damon, do you know?
I think he froze. Seemed like he's breaking up. Did you hear that? Did you hear that, Mr. LeBlanc?
No, I didn't, Judge.
Okay, Mr. Okay, Mr. Stanford, you're breaking up.
Uh-huh.
Okay, how much time do you need to pay the restitution? Oh, he just. Okay. We'll wait
Judge.
for him to zoom back in. I was thinking about 60 days.
Okay, Judge. And then he may have an issue with the amount, and so I need to get with the prosecutor on that to verify it.
Okay, we're gonna reset. Okay, that's him.
Both
right
of
there.
those need to be done when the.
Yeah, you need to be here in person.
Here.
Yeah, but
Yes.
We'll wait for him to come back in. I admitted him. I don't know what happened. I had admitted him and was taking him out the waiting room and he didn't. Something else must have happened. What's the date for 60 days? Is it December 13th?
And Judge, I can text him the date if he can't get, I think he's working out of town right now.
Okay, so it's gonna be December 13th. Okay. Mr. LeBlanc, it's gonna be set to December 13th.
Okay, thank you, Judge.
Okay, you can send him that. Let him know he need to stay in contact with you and his bondsman.
I will, Judge. Thanks.
And everybody need to be here in person.
Yes, Judge.
Okay, you're free to go and you have a blessed day.
Thank you.
It's supposed to say. It's Abdullah. Took care of here. Have got to get his paperwork. Eddie Dixon. There's a waiver of counsel in file. Good morning, Mr. Dixon. How are you doing? You doing all right? That's good. Mr. Dixon, hold on, let me look at your file right quick. Let me see, Eddie Dixon, okay. Now, last time you was here, Mr. Dixon, which was August 4th of 2023, at that time, you signed a judge's explanation of rights to defendants without attorney. And you indicated that you wanted to waive your right to an attorney and represent yourself. Is that correct?
Yes, sir.
And you also signed a waiver of counsel. Is that correct?
Yes, sir.
Okay. So have you,
Because the last time I came, you said they didn't have a paperwork together, because I was trying to enter a plea of no contest, because I didn't want to fight this.
you said paperwork, okay.
Yeah, because you told me that the DA wasn't here or something.
Oh, okay. Let me do this here. We'll give you an opportunity to talk to the prosecutor this morning, then we'll come back and revisit your
Okay.
case. Okay, just have a seat.
All right, sir.
The judge, this was, who is Mr. Abdul?
Dixon,
Dixon.
no, Mr. Abdul he did some paperwork.
Apologize.
Yeah, just have a seat.
Okay.
Ty G, Dwayne Mitchell. Good morning. This is cause number M332718, case of style state of Texas versus Ty G. Dwayne Mitchell. Mr. Mitchell, is that your full name?
Yes, sir.
How you doing, Mr. Mitchell? You doing all right? That's good. Now, Mr. Mitchell, the last time you were here, which was August 15, 2023, you indicated on your judge's explanation of rights that you wanted to hire your own attorney. Hmm?
Yes, sir.
Have you hired your attorney?
You need more time, sir.
You need more time? How much time you need? 2 months?
Yes, sir.
Okay, let's reset his case for 60 days. Okay, it's gonna be reset to December 13th, 2023. Once you get your reset from our court coordinator, you'll be free to go.
Yes,
And you
sir.
have a blessed day.
You too, sir.
All right, you're welcome. Next case is cause number M332914, case of Styles State of Texas versus Justin Keith Payne. Mr. Payne? Mr. Payne. Okay, now, Mr. Payne, the last time well, first of all, Mr. Payne, how are you doing? That's good. Now, Mr. Payne, your full name is Justin Keith Payne?
Yes, sir.
Mr. Payne, the last time you were here, which August the 4th of 2023, that case was reset from May 9th of 2023. At that time, on May 9th, you indicated to the court that you wanted your case reset to hire your attorney. Have you hired your attorney?
Keenan Smith. He started bed working, so.
Oh, so you had surgery? Okay, so you fully recovered?
Yes, sir. I'm
Okay.
working.
Okay, so that kept you out of work and now you're back working. So how much time do you think that you need to hire your attorney since you're back working? Let's reset in 60 days. Okay, we're gonna reset you 60 days. All right, okay. Okay, we're gonna reset Mr. Payne. Okay, January 3rd, okay. Actually, she's gonna reset you about 2.5 months. Okay,
It just needs your,
that's 2024, right?
yeah.
Once you get your reset, you're gonna be free to go and you have a blessed day. Do we, Mr. Abdullah, would you please bring your paperwork up? Ms. Bailey, did you get that paperwork from Mr. Abdullah? Thank you. Okay. Now, he didn't, he was fill out a response there. No, he didn't even fill out the back. He's supposed to, let me do this here. You're gonna have to sign and date this, do all of this. information. I'm supposed to fill this info out too, all that. Just have a seat, tell me, you have to fill out this information here. You know, even if it's done with zeros, if it doesn't apply, then you're gonna have to fill this information out. This is only the day's date and your name, you're gonna read it and you're gonna sign it and date it. And here, down here, that's gonna be Jefferson, because it actually for the county that you're in, it'll be Jefferson County and the day's date. All right, and once you get finished that, you just stop and then just bring it back to me. Yeah, he can have a seat. Mr. Let me see. We just did Deal. We doing Rocky Lewis. Okay. Yeah, hold on a minute. Jefferson County Court, law number 2 is back in session. The court is in session and calls numbers 23 CCCR 0064 and calls number M333436. Both cases, style the state of Texas versus Rocky Lynn Lewis. Mr. Lewis, is that your full name? Mr. Lewis, would you please raise your right hand? Mr. Lewis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Lewis, you may put your hand down. How are you doing, Mr. Lewis? You're doing great. That's good. Now, Mr. Lewis, you're represented in your case by your attorney, Attorney Joel Vasquez. Attorney Vasquez, how are you doing?
Good, Your Honor. How about yourself?
I'm doing fine. Thanks for asking, Mr. Vasquez. Do you waive a record in Mr. Lewis's cases?
Yes, Your Honor.
State is represented in this case by Haley Simmons. Simmons, how are you doing?
I'm good, Your Honor. How are you?
I'm doing fine. Thanks for asking. Now, Mr. Lewis, in cause number 23 CCCR 0064, I have before me a document that is titled Information. This information was filed on or about, well, this information alleges that on or about November 17th of 2022, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed to Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Lewis, do you understand what you've been charged with? And to this charge, Mr. Lewis, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charge? Mr. Lewis, I also have before me a document that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit number 1. Mr. Lewis, do you recognize this document? On page 2 of this same document, there are a set of initials RL on a line next to a box that's checked. A little contendory, which means no contest. Did you place your initials on this document?
Yes.
And on page 3 of this same document, I also have there's a signature above the line that is titled Defendant. Is this your signature? On the next document that is titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Discovery Certification. You recognize this document? And is this your signature on the line that's titled Defendant? Mr. Lewis, before you sign and initial these documents that I just showed you, did your attorney, Attorney Vasquez, go over these documents with you?
Yes.
And did you read and understand everything that he went over? And is everything in these documents true and correct to the best of your knowledge? Mr. Lewis, are you a citizen of the United States?
Yes, sir.
State, I have before me States Exhibits 1 and 2. State, you like to offer States 1 and 2?
Yes, Your Honor.
No objection.
Any objections? No objections. States Exhibits 1 and 2 are admitted. Mr. Vasquez, you advised in counsel, Mr. Lewis, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Lewis, your attorney, Mr. Vasquez has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Lewis, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
The state's offering in exchange for a plea of no contest or guilty, 180 days jail over 12 months probation, $1,000 fine plus court costs, 80 hours community service plus interlock standard DWI terms and conditions. And in addition to that, at the request of the complaining witness and calls M334360, the state will dismiss that case.
Okay. What is this, a court cost?
377.
377.
Yeah.
And Mr. Vasquez, you appointed in this case?
Yes, sure.
Okay. Mr. Lewis, the state is offering that you serve 180 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During this 1 year probationary period, you'll be required to pay a fine of $1,000 plus court costs of $377 plus a probation fee of $60 each month, or your analysis fee of $15 each month. You'll also be required to pay a reimbursement fee of $15, and you'll be required to reimburse Jefferson County the court-appointed attorney's fees of $250. Your total monthly installments, that is, the total amount that you will be required to pay each month is $231 a month. Will you be able to pay the $231 each month?
Yes.
You will also be required to perform 80 hours of community service, install an interlock device on any vehicle that you own or operate, attend and complete the DWI education class. You'll be required to adhere to the standard terms and condition of the probation. You'll be required to have an alcohol and drug assessment. You'll also be required to pay DWI an initial evaluation fee, $125 on the day of the plea should the evaluation be needed. You'll be required to pay an additional $50. And the state will be dismissing cause number M333436, which is a companion case. Now, Mr. Lewis, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Lewis, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Lewis, you're gonna stand next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day. Okay, you're welcome. Thank you.
Thank you, Judge.
You're welcome. I'm signing a dismissal now. Mr. Abdullah? Miss, what else? Okay. Court is back in session in cause numbers 23-CCCR-0716, cause number 23-CCCR-0717, and cause number 23-CCCR-0718. All three cases are styled the state of Texas versus Servion Xavier Abdullah. Mr. Abdullah, would you please raise your right hand? Mr. Abdullah, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Abdullah, you may put your hand down. How are you doing, Mr. Abdullah? You doing well? That's good. I'm doing fine. Thanks for asking. Mr. Abdullah, I have before me, I have this affidavit. I need Miss Woodle. Okay, never mind, I have it. Okay, Mr. Abdullah, I have before me two documents. First document is titled "A Judge's Explanation of Rights to Defendants Without an Attorney." You recognize this document? And is this your signature online as titled defendant? Or these your initials online stating you want to apply for a court-appointed attorney? I also have another document here. This document, take these arrows off. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled defendant's signature. Is this your signature? Now, Mr. Abdullah, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? And Mr. Abdullah, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in these cases is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will also be given information to contact him. Our court administrator, Ms. Brayla Jackson, she's going to give you that information. Now, once you get that information from Ms. Jackson, you'll be free to go, and you have a blessed day. Now, please have a seat in that first chair by the wall. You're welcome. Okay, that's fine. Ms. Jackson. Next case is cause number M332006, case is filed in the state of Texas versus Paul G. Bill. Where's the first sheet? I got this, the back sheet. Did y'all fill out one? No, in a second. Oh, okay.
In a second.
Hey. Okay, this is cause number M332006, case is filed in the state of Texas versus Paul G. Bill. Mr. Bill, is that your full name?
Yeah.
Mr. Bill, would you please raise your right hand? Mr. Bill, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Bill, you may put your hand down. How you doing, Mr. Bill? That's good. Mr. Bill, you're represented in your case by your attorney, John West. Attorney West, how are you doing?
Great, Your Honor, thanks.
Mr. West, do you waive a record in Mr. Bill's case?
Yes, we do, Your Honor.
Mr. Bill, I have before me a document that is titled information. This information alleges that on or about February 28th of 2022, while you were in Jefferson County, Texas, that you committed the class B misdemeanor offense of attempt to elude a police officer. Mr. Bill, do you understand what you've been charged with? And to discharge, Mr. Bill, how do you plead guilty, not guilty, no contest? No contest? Now, guilty? Okay. Now you're pleading guilty freely and voluntarily?
Yeah.
And are you pleading guilty because you are guilty?
Yeah.
Mr. Bill, I also have before me a document that is titled misdemeanor plea admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there are a set of initials EB on the line next to a box that's checked guilty. Did you place your initials on this document?
Yeah.
On page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Yeah.
And on the next document that is titled trial court certification, a defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes that's checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yeah.
I also have before me a document that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled defendant? Assistant prosecutor has to sign this. Now, Mr. Bill, before you signed and initialed all of these documents that I just showed you, did your attorney, Mr. West, go over these documents with you?
Yeah.
And did you read and understand everything that Mr. West went over?
Yeah.
And is everything in these documents true and correct to the best of your knowledge? Mr. Bill, are you a citizen of the United States? State, I have before me States Exhibit 1, state you like to offer States Exhibit number 1.
Yes, Your Honor.
Any objections?
No, Your Honor.
No objections. States Exhibit number 1 will be admitted. Mr. West, you advise and counsel Mr. Bill. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Bill, your attorney, Mr. West, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided fully effective and competent legal representation? Mr. Bill, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor.
What is that agreement?
The state's offering in exchange for a plea of guilty or no contest, 5 days in jail with 5 days credit.
And tax and retired court costs?
Yes, Your Honor.
Okay, Mr. Bill, the state is offering that you serve 5 days in Jefferson County Jail. However, you would not have to serve any more time in the Jefferson County Jail in this case, because you've already served 5 days in jail. Therefore, you'll be given credit for the 5 days that you have already served. The court costs in this case will be taxed and retired. That simply means that you will not have to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Bill, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Mr. Bill, I'll follow the plea bargaining agreements that you have entered into with the state. Now, Mr. Bill, you're gonna stand next to your attorney, follow the clerk. Once you finish following the directions of the clerk, you'll be free to go. And you have a blessed day, Mr. West. You'll be free to go as well, and you have a blessed day.
All right. Thank you.
Okay. Did we hear anything from,
Say,
I don't think we have any more pro se.
you got a post.
Oh, I do? Oh, okay. Okay, before we do that.
Adam said his attorney was. That was a while ago, he said 15 minutes ago.
Okay,
I spoke to,
yeah, he's on his way from out of town. Okay,
Yes, sir.
let's see. Um,
Did want to speak to he was out here. Did I call you? Yeah, you did. What's your name again? Yeah, my attorney.
so,
On the last page, Judge David Moreno, he does not.
What is that?
I'm looking for that.
There you go.
Dixon.
I don't know, but he know, I just don't know what was going on there. Yeah.
Yeah.
Level.
August 4th.
I'll bring it over.
Next case is cause number M 333-986. Case is South State of Texas versus Eddie Dixon. The fine is, there's no fine.
$800 fine.
Okay, I was just, okay. Down here, okay. Mr. Dixon, your full name is Eddie Dixon?
Yes, sir.
Mr. Dixon, would you please raise your right hand? Mr. Dixon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Dixon, you may put your hand down. How are you doing, Mr. Dixon? I'm doing fine, thanks for asking. Mr. Dixon, before we get started, I have before me two documents. The first document is a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. This document was signed on August 4th of 2023. And this document is a set of initials, but there's a signature that's reads Eddie Dixon, and there's a set of initials on a line that states, I want to waive my right to an attorney and represent myself. Now, also, I have another document. This document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And in this document, it states that on August 4th of 2023, it was signature Eddie Dixon, in August 4th, 2023, that you wanted to waive your right to an attorney of counsel. Is that correct?
Yes, sir.
Now, prior to signing and initial these documents on August 4th, 2023, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay. Now, Mr. Dixon, I also have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Eddie Dixon, on or about September 30th of 2022, while you in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Dixon, do you understand what you've been charged with?
Yes, sir.
And to discharge Mr. Dixon, how do you plead guilty, not guilty, or no contest?
No content.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight, or contest the charges. Mr. Dixon, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials. There are two sets of initials. The first set of initials are on a line next to a box that says check nola contendere. Did you place your initials on this document? I know the contendere means no contest. The next set of initials is below a paragraph that is titled Discovery Admonishment, and it is on the line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document in this location? All right. On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box says check states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Dixon, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Mr. Dixon, are you a citizen of the United States?
Yes.
State I have before me State's Exhibit 1, State and State's Exhibit 2, proper cause affidavits, which is in the court's file. State, would you like to offer States 1 and 2 in evidence? Now, Mr. Dixon, the state is offering State's Exhibits 1 and 2 into evidence. State's Exhibit 1, first document that I show you that you acknowledge that your initials was on page 2 in these 2 locations, and your signature was on page 3. The state would like to use this document as evidence in your case. The state is also offering the police report, what we call a probable cause affidavit, to be used as evidence as well in your case. Is it all right for the state to use these 2 documents as evidence in your case? Okay, and before we go any further, Mr. Dixon, you have a right to have a record of this case. That means you have a right to have a court reporter to type up everything that is being said. You also have a right to waive or give up your right to have a record in this case. Do you waive or give up your right? You waive it? All right. Now, State's Exhibit number 1 and 2 will be admitted. Mr. Dixon, is there any evidence that you are currently mentally incompetent to stand trial? All right. Mr. Dixon, I will accept your plea of no contest. I will find that you are mentally competent to stand trial based on my observations and based on the communications that we've had. Also, the court will also find that your plea and waivers was freely and voluntarily given. And the state will also find that the court will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement in this case?
We do, Your Honor.
And what is the agreement?
In exchange for a plea of guilty or no contest, the state agreed to recommend 90 days in Jefferson County Jail probated for 1 year, $800 fine and court costs, 60 hours community-based service judge, and any other standard terms and conditions for a DWI first offense.
What is the court cost? $377. Now, Mr. Dixon, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail in this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $800 plus court costs of $377. You'll be required to pay a probation fee of $60 a month, a year analysis fee of $15 a month, a reimbursement fee of $15, and you'll be required to pay a DWI initial evaluation fee on the day of the plea. Should a further evaluation be needed, now the DWI initial evaluation fee is $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $190 a month. Will you be able to pay the $190 each month?
So how much the whole total is? Whole total of all?
You're talking about the whole total
Yeah,
without, okay. The total is $2,092.
that's supposed to be paid to the probation.
Yeah, but you can pay it off.
Okay.
You can pay it off in monthly installments of $190 a month. Will you be able to pay the $190 each month?
I prepare 125 a month, if that's not. But I'll be finished paying for it before the year is up, though.
Yeah, but I mean, the deal that you would have to pay the $190 a month. Now, if you can't pay it, we have an affidavit on affidavit of injuries.
But doesn't, and I don't want to speak for Mr. Dixon, he does have a job and he travels, so
Yeah.
I don't know if he's gonna qualify for as indigent. I mean, he's gainfully employed. So I don't know.
I mean, but
He might-
if he said he can't pay it, what I'd have to do is get him to fill out an affidavit right quick so we
No,
can look
don't
at
have to do all that, they're gonna get paid regardless. I'm gonna pay it.
it. So you're saying you'll be able to pay the
Yeah, I'll
$190 a
pay it.
month?
It ain't no problem.
Okay. Now, you also, if you're paying it in a lump sum, but I mean, you don't have to pay it in a lump sum
Broken down.
if you don't want to.
That's what I paid. Now you can pay more. It's just that's the minimum. He's
Right.
taking it down to 12.
Okay, we good.
Okay. Now, you also be required to perform 60 hours of community service. You'll be required to attend and complete a DWI education class, have a drug and alcohol assessment, and you'll be required to adhere to the other standard terms and conditions of DWI probation. Now, Mr. Dixon, do you understand the
That's
state?
within probation.
Yeah, they'll go over all of this with you
Okay,
at the probation office.
uh,
Now, do you understand the state's offer?
yeah.
Do you think that the state's offer in your case is fair and just?
Mhm.
And do you accept the state's offer?
Yeah.
Okay, now, Mr. Dixon, I'll follow the plea bargaining agreement that you have entered into with the state. You're gonna stand in front of our court clerk right here to my right, follow her directions. Once you're finished following her, right here. Yeah, once you're finished following her directions, okay, well, all right, once you're finished following her directions, you'll be free to go and you have a blessed day.
All right, thank you.
All right. I think we had another guy. David Moreno. Well, this is cause number 23CCCR 0182, case of South State of Texas versus David Moreno. Mr. Moreno, is that your full name?
Yes, sir.
How you doing, Mr. Moreno? I'm doing fine. Thanks for asking, Mr. Moreno. You were in court on August 29th, 2023. On that date, you signed a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And on that document, you indicated by your initials that you wanted to reset this case to hire your own attorney. Have you hired your own attorney?
Well, no, sir, I haven't looked into that because for this case, I'm not really guilty for this case. I have video of it.
Okay, well, that wasn't my question.
Well,
My question was, okay, so you haven't hired an attorney. So based on your statement, are you gonna hire an attorney or are you not gonna hire an attorney? Because the court gave you three options, you remember? First option was you have a right to hire an attorney. Number two, if you could not afford to hire an attorney, then you can request that an attorney be appointed to represent you. Or number three, you can give up your right to have an attorney, which means you can waive your right to have an attorney and represent yourself. Okay, so you stated that you indicated on the document that you want to hire an attorney. However, you indicated today that you're not going to hire an attorney.
I was going to, but I didn't have the money coming up for it, so
Okay, let me now, based on what I stated to you earlier, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Do you understand that? Okay. Now, do you want to request that an attorney be appointed to represent you?
Yes, sir.
Okay, just have a seat and we're gonna get some paperwork to you that you need to fill out. Yeah, he can sit back there. She's gonna, they'll bring it to him. You need to do the judge's explanation and the affidavit of business.